Well, Justice Kagan asked my questions better than I could have. How do you suggest we reach this case on the merits expeditiously?
There's a number of tools the court could do that. We think this case is one that cries out for percolation, that the court should allow the lower courts to address the merits issue multiple times. It's currently on briefing in 3 different cases in the First, Fourth, and Ninth Circuits, and we think that that's the appropriate way to do it. If the court disagreed, obviously,
when you lose one of those, do you intend to seek cert?
If we lose, yes, absolutely.
Justice Kavanaugh?
So the technical problem here seems to be class-wide relief without the district courts going through the steps to assess whether a class should be certified, correct?
Correct.
Okay. And if you win here on this procedural point, it seems very likely that the day after, there are going to be suits filed all over the place seeking class-wide treatment, maybe statewide classes, circuit-wide classes, maybe nationwide classes. I'm sure they're being prepared now, right? And on what basis would you oppose a statewide class?
I could imagine certain bases, and again, we haven't briefed this in the lower courts yet.
You've been promising everyone here that Rule 23 is the cure-all. And I want to explore on what basis you would oppose a statewide class. Just take that one for now.
For example, and again, this is very hypothetical because I'm not predicting that we will or will not oppose that. We haven't taken a position on that yet.
If you were to oppose it, on what basis would you plausibly oppose it?
There may be problems of commonality and typicality, for example. For example, there's 2 different sets of groups that are affected by the executive order. There are those where the mothers are temporarily present and those where the mother are illegally present. And in both cases, the father is neither a citizen nor a lawful permanent resident. So there might be issues of typicality. Adequacy of representation might very well be an issue. So there would have to be that rigorous application of those criteria. Now, the argument may be this is a case that is a natural candidate for a Rule 23b2 certification. That may well be true. The government hasn't taken a position on that. Our position is not that class certification will necessarily be granted. Our position is that Rule 23 is how these sorts of claims should be channeled.
And you think, I think you just said, it's very possible that class certification may be granted.
It is possible. We don't know yet because there was a class certification motion filed at the very beginning in the Western District of Washington, and it was just never briefed because obviously the pathology here is that the nationwide injunctions just go blowing past the class certification procedures.
And I guess Rule 23b2, for a lot of the cases we've had over the past 25 years that you talk about where there have been universal injunctions or where the lower courts have had that, I mean, 23b2 could have been used in a lot of those, presumably, correct? Eviction moratorium, student loans, OSHA vaccine mandate. Do you see the possibility that 23b2 could have been used instead of, I mean, some of those were APA, but put aside the APA issue for now.
Yeah, we do set aside that issue, if I may.
I got it.
But yes, I agree with that as to some, but not of the other cases. It's hard to see how, for example, Biden against Nebraska might have, where a state was the plaintiff, might have been a 23b2 class. And the Alabama Association of Realtors might have been a much better candidate for that. And again, not taking a position on the individual merits, our overarching point is there's a tradition of equity in this country that goes back to the English Court of Chancery, and what's happening in these universal injunctions, again, 40 times in this administration, at least 22 times in the last administration, 64 times in the administration before that, is just disregarding those appropriate procedures to seek this kind of global relief.
I want to ask one thing about something in your brief. You said, quote, and of course this court's decisions constitute controlling precedent throughout the nation. If this court were to hold a challenged statute or policy unconstitutional, the government could not successfully enforce it against anyone, party or not, in light of stare decisis, end quote. You agree with that?
Yes, we do.
Okay. If you prevail here, the original executive order had a 30-day period before it took effect. If you prevail here, should there be any pause so that things can happen that need to happen for 30 days or some period of time, or should it just should we not even worry about that?
Yes, we can see that the 30-day ramp-up period that the executive order itself calls for never started because the universal TROs were entered almost immediately, and we don't dispute that there should be a 30-day ramp-up period. For another reason as well, which is that we've been enjoined from even doing guidance, even formulating a policy, and that itself is another problem with these injunctions.
On the day after it goes into effect, this is just a very practical question how this is going to work. What do hospitals do with a newborn? What do states do with a newborn?
I don't think they do anything different. What the executive order says in Section 2 is that federal officials do not accept documents that have the wrong designation of citizenship from people who are subject to the executive order.
How are they going to know that?
The states can continue to, the federal officials will have to figure that out.
How?
So you could imagine a number of ways that the federal officials could.
Such as?
Such as they could require a showing of, documentation showing legal presence in the country. For a temporary visitor, for example, they could see whether they're on a B-1 visa, which would exclude kind of the birthright citizenship in that context.
For all the newborns? Is that how that's going to work?
Again, we don't know because the agencies were never given the opportunity to formulate the guidance. They would had 30
They're only
days.
going to have 30 days to do this. You think they can get it together in time?
They're under, that's what the executive order instructs them to do, and hopefully they will do so. Again, it's a speculative and hypothetical scenario because they were enjoined from even starting that process.
And then last question. You mentioned before this has come up in the last 4 or 5 administrations primarily. I guess I've thought about that a lot too. Why? It seems why might be it's harder to get legislation through Congress, particularly with the filibuster rule. Presidents want to get things done with good intentions. The executive branches that work for those presidents push hard to, when they can't get new authority, to stretch or use existing authority. And they've been pushing. Understandably, all with good intentions, all the presidents, both parties, right, with good intentions pushing. Is that your understanding of why this has happened more, that there's less ability to get legislation? Because I'm trying to figure out the why to your opening about the last 4 or 5 administrations. I agree with it. I think that might be the why, but I'm curious what you think.
I'm speculating about the motivations of the individual district judges who grant these, but one explanation might be this is an extraordinary power. It's a very strong power for the reasons the questions have reflected.
Well,
for a district
let me
judge
just pause you right there. The underlying point is that these district judges are not just doing universal injunctions. They're finding these actions illegal because they're exceeding existing authority, and oftentimes we are too, when it gets to us, finding the actions of presidents of both parties unlawful because they exceed existing authority. So is that coming up more often because of, why is that coming up more often?
It's hard to do an historical analysis, but I would draw an analogy to the New Deal. And Professor Bray makes this point in his article that actually there were very, very passionate challenges to sort of nationwide policies during the Roosevelt administration, and they were not addressed by issuing universal injunctions. He cites an example where in one case, a policy had been held illegal, and there were like 1,600 injunctions against that policy, all protecting the individual plaintiffs. So if you look at the history, it's not clear that what we have of, disagreement, but difficulty, gridlock, getting things through Congress and so forth, that's not necessarily new. What is new, and is certainly unique to the last 5 presidential administrations, is having these given on this widespread basis and this systematic basis, 40 again in the last 4 months.
Thank you.
Justice Barrett.